everyone. Welcome back to our session on academic skills. Last month, we worked on reading and briefing, and this month we're going to work on outlining, specifically in preparation for your exams. I know that some of you have already started taking your midterm, so this might be more of a refresher or as a way for you to kind of see, does your outline work or not for you. I am one of the chairs of the Armenian Bar Association Student Affairs Committee. Grant Petrosyan is the co-chair of the Student Affairs Committee as well. This is part of that three-part series, and next month we're going to end with exam writing. So today I'm going to make it brief, but Rafi and Mire, if you have questions, please go ahead and unmute and ask me questions as well. Okay, so what we discussed last time was you brief an IRAC so that every day after class, you synthesize the notes and you start developing kind of the framework of your outline. But your framework of your outline would have already started by anchoring. And by anchoring, I mean when you look at the table of contents and you look at the core syllabus and you pretty much make the skeleton of your outline simply by issues. What are all the issues that you're going to be learning about? So if it's in the world of torts, three big issues generally will be intentional torts, negligence, strict liability, and maybe product liability. So that's kind of your big skeleton of just torts. And then from there, you're going to break down torts into or intentional torts into harm to person versus harm to property. And then from there, you're going to start breaking down into mini IRACs. So what I want to do is kind of show this to you and then walk you through it. Sorry. Okay. So if we looked at the table of contents and the core syllabus for, let's say, torts, we saw that the first thing that we learned about was the simple requirements of tort. That every tort has to have a voluntary act and then an intent or kind of the mens rea, which is, again, very similar to criminal as well. So based on that, what I was proposing is every day after class, if you know that, for instance, you read about Cohen versus Petty. And if you anchored Cohen versus Petty, you would have seen in the table of contents that it was listed under voluntary act. So you know that the only reason you're reading Cohen is to determine whether or not the act in that case was voluntary or not. From that case, you also pulled the rule. At that time, I would also recommend you to use supplemental resources like secondary sources or examples and explanations. You could use Barbary outline if the rule isn't so well enumerated in the case law, or even in class. I would actually recommend that if there is a rule that the professor states very clearly on an issue, use that rule that the professor has given. Because after all, the professor is going to be the one to grade your exam. And so the professor is going to want to see the words that he or she stated in class. So the way I organize it is, notice this is the I, this is the R, so issue, rule, and analysis. Conclusion is embedded here, but really at the end of the day, remember also, and later on when we transition to exam writing, conclusion is the least important. Typically, your conclusion is going to get only 1 point. Your issue is only going to get 1 point. your rule might get 2 points, and then the bulk of the information is going to be, 3 to 5 points just on your analysis, which shows that this part is going to be the most important. So if I know that Cohen versus Petty, or even bigger picture, that every tort is going to require voluntary act and an intent, then my outline is going to show that 1, requirements, and I could even make it more specific, requirements to intentional tort. The first requirement being voluntary act, and then the rule is act is voluntary if foreseeable and aware or conscious of action. So I've kind of shorthanded and made it very brief, because I know that at the end of the day also, I'm creating my outline in preparation for memorizing the rules later on. So I need something very pungent and quick that I could remember. So I pretty much know that there's 2 components. It's foreseeable and aware, or am I conscious, meaning am I aware of what I'm doing? That's it. It's 2 requirements for voluntary act. So then what I like to do is I take my briefs, and I know that as it related to voluntary act, we only had 1 case. I split it up. Is it a yes, meaning was voluntary act satisfied, or no, it was not satisfied? The reason I also outline like this is because I'm already preparing for exam writing, because ultimately this will be my heading issue. This will be my rule without the bullet or the word rule. And then I'm going to have 2 paragraphs. On the one hand, X, on the other hand, X. And then I'm going to have conclusion. Therefore, voluntary act was met or not met. So I want an outline that is preparing me to write an exam early on. So what I would do is, let's say if Cohen versus Petty was about the issue of voluntary act, and it did address both, whether or not it was foreseeable and whether or not he was conscious at the time of the accident. Then what I would say is, if the conclusion was no, it was not a voluntary act, then I would say act was involuntary. 1, because he felt ill. 2, he didn't know about the illness, because then that addresses foreseeability. So even though you became sick, did you know that you're prone to getting sick? If you are, then it would be a voluntary act. 2, the illness was sudden to the point that he suddenly fainted immediately after telling his wife that he was sick. Also, there was no time to stop. So between the time that he got sick and the time that he had an accident, there was no time to change course or change direction. There wasn't any sense of consciousness to control the action. And so that again shows that it was not voluntary. He has no prior history, and he fainted right before the crash. So what you want to do from these cases is identify the key facts. The key facts that are either going to satisfy or not satisfy these elements of the rule. Why am I saying this? Because, again, if you're writing an outline in preparation for the exam, then these facts are going to be the ones that you're going to use to either distinguish or analogize to the facts in your case. That's the art of analysis. Instead of just coming up with some reason for why an element is met or not met on your exam, all you have to do is look at precedent case law, which is technically what every lawyer needs to do. Every decision is based on precedent law anyway. And day in and day out, lawyers are just either distinguishing or analogizing to the facts in the precedent case. And if the facts match up, then the reasoning is going to be the same, and so will the conclusion. If the facts don't match up, then the reasoning will be distinguishable, right? You're going to find a different reason to explain why this case doesn't apply, and therefore the conclusion will be different. Now, why do I put yes here? Because in class, your professor is going to give other hypos. Any hypo that the professor provides that is either going to satisfy or not satisfy that element should be listed in this outline. So if the professor said, for instance, that person happens to have seizures, and this wasn't the first time that the person has had a seizure, so I would put that under yes, that the person has a history of seizures. And then if I add also that, what if we added a fact that, but let's say the person had a seizure 5 years ago, but during 5 years ago, it was several seizures, and then he started taking medication, but then all of a sudden he improved. And so he decided that with his doctor that he no longer needs to take the medication because for whatever reason the seizures aren't there, or he's taking other treatment that's not medical. Well, what about foreseeability? That's something to be argued. Then is the act voluntary or not when the person chose not to or to stop taking the medication that would have prevented the accident? So that's why you want to be a very active listener in class to see what tips and facts is the professor providing so that you could add into your outline. And here's another reason. It's a clue into likely what the exam is going to be about. So if you see a professor spending a lot of time on a specific fact or a specific hypo, you should say, you know what, maybe this is something that the professor is thinking about actually testing us on. Sometimes the professor will also say, this is my favorite aspect of the issue. Again, if the professor says something like that, that's a signal to you that it'll likely be on an exam. So that's why if you have a very good brief that kind of already does this, but obviously doesn't need to have the yes and the no, but it already says, okay, the issue is whether or not in fact, in the brief, I did mention that you should write the question in a way that provides a yes or no answer. So it's easy. So you know at the end of the day where this is going to fit in. So did the person act voluntarily when, and give all the key facts? And then here's the rule: act is voluntary if it is foreseeable and if the person is aware or conscious of the action. And then from there, give the analysis for why something was voluntary or not voluntary by matching up the facts to the element. So then I'm going to move to this one. So here, then the other component of intent is, intentional tort is intent. So the act is intentional if one is substantially certain that their act will result in harmful or offensive touching. Well, the touching, it should be harm. The touching is more so for the harm to person, but like for battery, but essentially, again, it's the act that it's either done intentionally or substantially certain that it's going to result in some harm, right? Again, so it's two elements. Now, the case that was referring to intent was Garrett. And so the issue, though, was, did it meet one or the other element or both? And the court ultimately said one, it actually did not meet the intentional requirement, because and by intentional, it means, was it purposefully done, right? Are you doing it with the purpose to? And that was no. But the question was, when he pulled the chair from under the, when the person was about to sit and he pulled the chair, but it was with the intent that the person would sit and the person fell. Did the kid know, or was the kid substantially certain that by doing that, the person was going to fall? And the court said, but we need more clarification here. And so that's why here there's the unclarity. Now, maybe I would put maybe. Here's what I would say. In class, your professor is going to elaborate on that. And your professor is also going to give different hypotheticals to say, okay, well, what difference would it make? Like, okay, well, if it was pulling away from the person, that's purposeful. But if it's pushing the chair towards the person so the person could sit, well, did the person know that that the person was in fact going to sit right there? What was the distance between the chair and the person? So these types of facts, you want to, again, be very active as a listener in class so that you are including all this information in preparation for your outline. So then if we transition to harm to person, or let's say intentional tort. So again, intentional tort, what I would do is I would divide it into two components: harm to person versus harm to property. If it's harm to person, these are the different issues. And then if it's harm to property, it'll be the conversion, trespass to chattel, and trespass to land. So again, here, battery would be the issue. The rule would be act as considered if it was intentional infliction of physical or offensive contact to a person. Now, what you could do if you wanted was divide this up even more, where you, instead of saying yes and no, maybe divide it based on the specific element. Here's what I mean. Some elements are going to be more contentious than others. So I'll give you an example for this as an example. So intent, that purposeful is usually going to be more of a slam dunk, and substantially certain is going to be less of a slam dunk. So maybe what I would do is I would separate it. And in fact, let me see if I could stop sharing and show you a different way. Sorry. So let's say if I said intent has two elements. It has purposeful and it has substantial certainty. Or no, I should say knowledge. I could divide this up, yes and no. This again is going to be slam dunk. So I could even say no, like with Garrett. Versus here, yes and no, and I could put unclear, and again, he pushed it, pushed the chair. Something like that. And then same thing here, and I'll make this bigger. And so where it's saying like unclear. So what I'm doing is I know that this is usually going to be a slam dunk issue on an exam. It's not like you are going to argue on the one hand this, on the other hand there. Usually not on an issue like this, because this is more clear cut. Something that's going to be more ripe for discussion would be an issue, a secondary issue or an element that has more room for discussion. And so sometimes it might be good to separate the elements as well. So let's say if it's battery, it's intentional infliction of, let me see, what was the offensive contact to a person. What I might do is, again, the intentional infliction is going to be this, the purposeful, and the knowledge with substantial certainty. Then there's a physical issue, which is very different. A physical contact is very different from an offensive contact. And then to a person. So I might even divide, I might write my rule, and you have multiple ways of doing it. You could do it where if this is clear, where you put the main rule here, and then you can divide it into sub-elements like here, or you could do it in the way that I did it before. And then within each, you could break it down into yes and no. It's your choice how much you want to break down your outline, because it could be as simple as what I had up before, or you could break it down even more detail so that you don't miss anything. because also each of these sub-elements, like sometimes each of these sub-elements will be an issue, and each of these will have its own definition. So like, what is offensive contact, right? This is going to have a definition. And the definition for offensive contact is going to be very different from the physical contact. And then same thing with to a person. What is the definition? How is to a person defined? Because it's not just the person, like, so for instance, if a person snatches a purse from me, it's not like they hit me. They never got direct contact with me. If they only grab the purse, it's still considered battery. Why? Because it's attached to me. It becomes my body essentially when I'm holding it. So that's part of the definition. Well, if you've read cases pertaining to each of these elements, or from that one case, if that one case is addressing each of these elements or some of these elements, then break it down. Identify the key facts from those cases that pertain to each of these sub-elements. And then I'm pretty sure your professor is going to do the same thing by giving hypos and other facts or fact patterns. Put those into this. The other thing I would do is, and this is why I was saying the supplemental sources are really good. Let's say if between your class and the book, the case, it doesn't cover all of these elements, but you still really want to beef it up in preparation for your exam. Those supplemental resources, like especially examples and explanations, it will actually give you examples of when something would constitute a physical contact versus an offensive contact. So something to think about in terms of how to really maximize, or even like Barbary outlines or Themis outlines, any other supplemental source that already has additional examples, you could add them in here. Again, what you want to do with your outlining is you will actually want to work on it on a weekly basis. So you have options. So let's say the first time I did it something like this, very detailed. But let's say the following week. So okay, maybe the first week I read the Holbrook case, and in the Holbrook case, it was pretty much like a sexual harassment case. The woman was working in the store, and then the guy was becoming very forthcoming and very just aggressive, even though she said no. So was it purposeful? Well, she made her intentions known and the person still continued. So yes. And then you would say, but even if it was not purposeful, very likely that the person had knowledge with substantial certainty that it was an act that was going to result in some harm. And here's why. So give your because. So again, put your yes. Well, there was no physical contact in the sense that there was no real touching, but there could have been offensive touching, like the things that were stated from his mouth or the aggressions that he was trying to make, even though there was no actual physical contact. Well, this also is based on reasonable person standard, which would be part of the definition. I would put all of that and the facts up here. And to a person, yes, it's to this individual. Now, let's say I did this first week. My second week, when I come back, what I want to do is revisit this outline. Not only am I going to add new information to this outline, so like let's say if the following week I'm working on assault, and I'm going to put the rule on assault in the case and everything. Not only am I going to add this, what I want to do then is create another document where I'm really condensing. So what you want to do is every week you're seeing the same thing day in and day out. You're not memorizing, you are processing. And that's why for me, truly up until by the time I got to the last 2 weeks of the semester, I had already memorized everything. Not because I was intentional about memorizing, but because I had processed it so much and I had touched the material so many times. So what I mean by that is, let's say if I want to condense it, then the second time, if this was my first time where I broke it down, then the second time could have been just something like this. So I know that if, again, sorry. if it's let's say harm to person, and I know that it's uh, battery, I'll give the rule for battery, and then all I would do is put yes and then no with the cases. And eventually what I'll do is I'll even remove the case name. All I need to know are the facts. And then let's say, so if week 1 of outlining was this kind of detail, week 2 of outlining ended up being like this, by week 3, really all I'm left with is harm to person, and then I'll have battery, and then all I'm going to have is the rule. All of this information is already in my mind because I've seen it 3 times. So that's why outlining is so helpful, because you're constantly condensing. Because come exam day, what you want to do is have a checklist. So if I'm constantly touching this, then by week 4, I would simply have harm to person. And the only thing I'll have thereafter is the list like battery, assault, false imprisonment, and whatever else there is, IED. I would even have the rule, because then the rule's also memorized, and also I have another document that has this all laid out. So what you want to do is constantly work on your outline. And if in 1 month, so about 4-week span, I've seen the same material day in and day out, I'm already memorizing. And that analysis is already in my mind. And what I would also recommend is, as you're going through this, sometimes engage with the different learning styles. So in the beginning, so I'm a very kinesthetic learner, which means that I need to use my hands to learn and process. So I flowchart. To me, it's the way my brain processes information. It does, my brain, if it's trying to learn something, does not do it in a linear kind of chronological format. It's more like process and procedure. And so I first start off everything with a flowchart. But then when I need to, okay, so once I've gotten past the understanding, and now I just kind of want to condense everything, then it does transition into a linear outline like this. And then once I've done the linear outline, because I'm also visual, so this gives me a visual as well, kind of very clear, systematic order, structure. Once I'm past that, then I'm getting closer to just memorizing. Well, it gets very boring for me to either just flowchart or to outline like this and then constantly condense. So that's when I tap into my auditory style of learning. Auditory for me is the lowest or the least dominant form of learning. I don't learn by listening or hearing. I learn by doing, and then I learn by seeing and reading and writing. But there comes a point that I've done this so often that I need to change the way I'm learning to keep it more still engaging. That's when I get a study buddy. And I recommend that you only have 1 study buddy, 2 max. I don't think you need more than that. Because I do think that the more people there are, the worse it is. Because then everyone is just giving all their opinions and no one is really doing the work. I actually think that 1 person is the perfect person, because you are supposed to do your study on your own. You're not supposed to do the outlining together. It's after you've outlined separately where you come together and now you're sharing your work to see, okay, are we on the same page? That's where you're sifting. So it's not like you're relying on the other person to do your work or to do the processing. That's why I don't think you should ever take another person's outline and just memorize it. I think it is absolutely crucial that you write your own outline. But if you want to sharpen each other, if you as a whole person come in with a very well prepared outline and so does the other person, you can actually sharpen each other and cross reference. And another thing I would do is if you're outlining early on, then this is your opportunity to take it to the professor and run it by the professor and say, okay, and you don't show the whole outline and say, is this a good outline? But instead, if there's a component that you think you're still iffy on, I would take that, I would take my full outline with me, but I would go into office hours and I would say, okay, professor, on this one, I'm wondering, can you look at it? Tell me what you think, or here's what I'm thinking about this issue. Or like I'm a little bit iffy still about the knowledge with substantial certainty. Can you give me additional hypos? And I would write my hypos onto that sheet. And the other thing I would say is with respect to office hours, most people don't go to office hours until the last 2 weeks, which I think is the biggest mistake for multiple reasons. One is I figured that I would get the most undivided attention when I went early on, which meant that if you're already, so you already started mid-August, you're into October, so you're about a month and a half in. I was already in office hours come week 2. And the reason is because one, I wanted the professor to know me personally. The other reason is I wanted the professor to be invested in me personally. Here's what I mean by that. You're already working on midterms now, and probably you're going to want, after you receive your grade, you probably want to meet with the professor one-on-one. Well, here's the problem. So will a bunch of your peers. But if I met with the professor early on, like 2 weeks into law school, and developed that relationship, the professor has a vested interest in making specific time just for me. Additionally, when exams come, I guess you'll probably, your exams will come pretty much right after Thanksgiving. So that means you have a month to go. In maybe 2 weeks or so, you should start taking a bunch of practice exams. Well, I want someone to review those practice exams. A lot of students wait until the last 2 weeks for the professor to review practice exams. There's no way if I have, let's say, 50 students, and it's actually more than that. So let's say there are 90 students and 30 of them submit practice exams for the professor to review, you're not going to get good feedback. But if you did that a month before everyone showed up, you're going to get excellent feedback. So why should you outline? Because the outline, so if I prepare my outline now, and in 2 weeks or so, I started taking a bunch of practice exams, I could really test the strength of my outline. Because if the outline is there, because notice a lot of how the outline is already drafted is in IRAC form. It's all there. The rule is there. The analysis is pretty much there. All you're going to do is, if I already have the key facts from the precedent case, I'm just going to analogize it or distinguish it to the facts in my case. So or to the hypo. So if I do that and I see it works out and everything matches up, then the outline, it works. If they don't match up and I'm not quite getting the analysis, then that means my outline isn't strong. And that's exactly when I would go to the professor and say, I see that there's a discrepancy between my outline and the final answer on the exam. How can I do to kind of bridge the two together? So that's more or less what I wanted to discuss about outlines, but I wanted to open up to questions if you have any. Nothing? Any questions? Okay, well, that was all I wanted to discuss on outlining. And then next month, we're going to get together again to go over exam writing. And I'm really going to show you how that outline then translates to an exam. In fact, let me do a quick preview of just IRAC, because I think, and I've seen this, I train a lot of new attorneys. And one of the I would say where new attorneys are really struggling is in their writing for whatever reason. And I would say of all the courses you'll ever take, legal research and writing is the most important. It's the one that you are going to apply even after law school. But there is such a discrepancy in either what you're learning in law school and how you're performing post law school, or just whatever you're being taught is not efficient or effective. I don't know. But I do know that writing has become severely deficient, even as basic as organization. So I want to show that for every exam, including your legal research writing, it is imperative that you identify the issues, and each issue should be identified with a heading. So if I've identified all the issues that are on the hypo, and let's say it's again on torts, and we're going to start off with battery, then you want a very clear heading so that the professor knows that the eyes are going to go straight to this issue. Meaning, check, you've identified the issue. Also, you're doing this in preparation for the bar. 3 years of law school are there not so that you become an effective lawyer, because you're not really going to learn to be a lawyer other than learning how to think. The 3 years of law school is preparation for the bar. Really, that's why it exists. So number one is battery. And here's why I say this. The exam proctor or grader on the bar is only going to spend about 90 seconds, minute and a half on your exam. So you better have a heading. Otherwise, the reader is going to assume that you didn't identify the issue. Even if you have the rule, even if you have the analysis, if you didn't put a heading, they're going to miss it. Yet then, every writing has to be an IRAC. To this day, in the work that I do, every writing is an IRAC. So give me the rule and make it very clear, right? Intentional infliction of physical or offensive contact to a person. And then say here. So this word is key. I want you to put the word here because it's the clearest indicator of analysis. So here, person intended to or committed battery when XYZ. You always also in law school and in your legal writing course, I'm pretty sure you're learning CREAC. So you start off with a conclusion, and then you go to the rule explanation, the rule application, and then again conclusion. Start off each sentence, each of your topic sentence should indicate your conclusion. What is your premise? Is this issue met or not met? And then give me the facts. And then you're gonna, because first you're gonna give me the facts, and then you're gonna say those facts satisfy the elements because. So this because is another indicator of analysis. It's your why. And then what you want to do is say conversely, the counter argument. Person may argue, or you could say like a defendant committed, plaintiff may argue that person did not commit battery, or defendant and give the facts. And then again at the because. And then the last key word is therefore. You do want to say therefore battery satisfied or not satisfied. As basic as this, but notice how this pretty much is going to match up with your outline. And that's what you want to do. So this IRAC is a non-negotiable in exam writing, and also in your outlining, and also in your brief, and also in all the cases. All cases are written in IRAC. So IRAC is something that exists whether you're in law school, post-law school, whatever job you do is always going to be an IRAC. Your bar is going to be an IRAC. So get into the habit of writing an IRAC in your outline so that you can easily translate it into your exam. So any questions about that? Okay, so if not, then we will conclude this session, and I hope you come back for the exam writing so that I could show you how to spot issues. Well, first I'm going to show you how to create a checklist of just the issues, then how to spot the issues, create the outline for the exam, and then actually draft the exam. So have a wonderful rest of your day.